All right, Bill Henry here with Robinson Henry, back for another Estate Planning Thursday. I was out last week. Lucas Fry, attorney here, does tax, elder law, and estate planning, filled in for me, but I'm glad to be back. So let's jump right in. I guess before we do that, as always, if you have any specific questions, make sure you talk to an attorney. Everything we go over is, of course, general, and no attorney-client relationship is formed by watching this Q&A or asking questions. So if you have any specific questions, reach out to us, reach out to another attorney. Make sure you get someone that's competent in the area you're looking for and they are licensed in your state. Okay, so let's get right to it. So first question, how can you pay a family member who is acting as their parent's caregiver without running into Medicaid issues? So I think what we're talking about here is if you are helping out a parent and you believe that your parent is going to need to qualify for Medicaid in the future, how can you get paid but not create a disqualification period? Because if your parent pays you and you don't do it right, all those payments are going to be treated as a gift. So everything you do for your parent, unless you do it under a caregiver agreement, we'll talk about that in a second, and it's done properly, everything that you did for your parent was deemed to be for love and affection and not for money. So what does that mean? That means that you can't retroactively get paid by your parents for work that you do. If you want to get paid for all the different services you're providing your parents, your elderly parents, the idea is then that Medicaid won't be needed as soon. And so therefore then they're willing to allow your parent to pay that money to you. And at the same time, you don't end up with this disqualification period. So what do you do? How do you solve this? You do it with a caregiver agreement, or in Colorado, we would call it a personal care services agreement. It's exactly the same thing. But what's most important to understand is that you have to do it right. And far too often, I see clients come in and they missed one little detail. And if you miss a detail, then everything is going to be counted against your parents for Medicaid purposes. So let me give you a few of the big ones to look out for, but just know there's a lot of rules around these caregiver agreements. And so you need a statute to know what's what. So first thing is, the agreement has to be signed by your parents before the services are rendered that you're going to get paid. It also has to be notarized. So that means you can't go retroactive. You can't have done all these different things for your parents and then all of a sudden say, oh, now I want to get paid for it, and here's this caregiver agreement. It's not going to work. It's got to be from that point in time forward. And you can't get paid for anything after the date that the Medicaid application is filed in Colorado. So that's the Colorado rule. Remember, every state can be a little bit different. So that caregiver agreement, of course, has to be in writing, has to be signed by your parents, has to be notarized like I talked about, and it has to detail what you're going to do and the frequency that you're going to do it. So how much time are you planning to spend on a weekly or monthly basis caring for your parents, and what specifically are you going to do? How much are you going to get paid? That also has to be listed. Now, you can't just get paid whatever you want. You can only get paid up to what's relevant in your community and what's reasonable. Well, so that's going to vary community by community. You know that it's not going to be less than minimum wage, but where's that number? It really, again, depends on where you live. $15 an hour, $20 an hour, maybe somewhere in there you can probably use for most communities. But again, you really got to understand what are other people getting paid. If you weren't going to do this work and somebody else was going to come into the home and do these things for your parent, well, what would that look like? All right. The other part that always catches so many people is, all right, you put together this great caregiver agreement, this personal services agreement, and then you don't track what you do. Well, if you don't track what you do, then you can't get paid for it. So what do I mean by that? If you're going to take them to the doctor, for example, well, you've got to write that down. I spent 30 minutes and this is what we did and this is where we went. So it's a contemporaneous log. So it's an actual log by the minute, so to speak, but whatever you're doing. So the amount of time that you spent and what you did, and it needs to be contemporaneous with you actually doing it. So every day after you do things for your parent, you're going to put down what you did. And remember, you've already dictated how much time you're going to spend with them. All right, well, those are kind of like the main rules around caregiver agreements. They can be a great tool because kids sometimes do a tremendous amount of work for their parents. They end up not working because they're caring for their parents. And so it's a good thing to have in your tool belt, but just know that most times it's done incorrectly. And so we really need to be careful when we're doing those. A little long-winded there, but a really important topic. Is there a downside to having a co-trustee? When would this ever be advisable? Is there a downside? I mean, I guess there's a downside and upside to everything. So what's the good news if you do co-trustees? Well, now you've got more than one person making decisions, and so therefore there's less likely for abuse, right? If I got 3 trustees and they all have to make a decision, it's a little bit harder for one trustee to steal property out of the estate or out of the trust. So what are the downsides? Well, it's basically exactly that. How are these trustees going to be handled? In other words, is it going to be that each trustee has the right to make a decision independently, or is it unanimous? My example, 3 trustees have to make a decision, or is it by majority? And if you only have 2 trustees, what if they have a conflict? How's that going to get resolved? So there could be some issues with. You got to be very clear with what the rights are of the individual trustee. The other problem is, just practically speaking, if I've got 3 trustees and I need a check signed, who has the right to sign it? Do I need all 3 signatures? Which is fine if that's what you want, but it's going to slow things down tremendously because I got 3 different trustees sign off on it. If I say, oh, any trustee could do anything for me, well, that makes it easier, but now we've kind of eliminated some of the reasons that we probably went to 3 trustees. Is it ever advisable? Yeah, I mean, I wouldn't say the majority of our clients do co-trustees. Probably about 10% of the time we see that. There's no magic as to, it's really specific to the people creating the trust. Husband and wife, very common, are going to be co-trustees, but they can each act for themselves. All right, big picture. How might the Secure Act affect my current estate plan? So the Secure Act was passed, let's call it January 1st of 2020, slightly before that, but that's good enough, January 1st, 2020. And the Secure Act changed, from an estate planning perspective, how IRAs are taxed to the phone ringing there. So how IRAs are going to be taxed to the 2 beneficiaries. So what do I mean by that? Let's use an example. So let's say I have an IRA and it's my IRA and there's $100,000 in it, and then I die. Well, if it goes to my spouse, then my spouse can take distributions out of the IRA over the course of her lifetime. So that is called her required minimum distributions, those RMDs. It used to be, if let's say my spouse wasn't alive and it was going to go to my kids, that my kids could do the same thing and they could take out distributions out of this IRA over the course of their lifetime. Well, the government decided they weren't getting enough tax revenue, so they changed how that happened. So instead of being over the course of my children's lifetime, it's now at a maximum of 10 years. That means all the money has to come out of the IRA within that 10-year period. So that's kind of the background on the Secure Act. So all has to do with retirement accounts and required minimum distributions, as we're concerned about it with estate planning. So now, would a trust be advisable? A trust isn't going to change that. It could change it for the worse unless the trust is specifically written to handle IRA assets. So whenever we have a trust as a beneficiary under a retirement account, if we can't look through that trust to see the actual underlying beneficiaries, then instead of being a 10-year payout, or in the case of a spouse or some other very specific scenarios, over the course of the person's lifetime, all the money has to come out of the IRA or the retirement account within 5 years. So we accelerate that even more. But let's say we draft a proper trust. It's not going to put us in a better position in terms of these distributions, because again, we're going to look through to these beneficiaries. What it can do, however, is give us asset protection for those children. So a quick story, this happened in 2014. There was a case where Ruth, this woman, had an IRA, and we're going to say there was about $300,000, and I don't honestly know what exactly was in it, but let's just call it $300,000. She gave it to her daughter, Heidi, upon her death. Heidi then goes off and files a bankruptcy. The bankruptcy court ultimately says, it goes on to the Supreme Court, bankruptcy court ultimately says, hey, that money has to be given over to the bankruptcy court and therefore paid to the creditor. So if we didn't want that to happen, what do? Well, we're talking about Colorado law. This could be different in different states. So instead, what we would look to do is create a trust. Those funds would then be funneled through this trust. The trust would be set up in such a way that it would give Heidi, in our example, asset protection, so that same result wouldn't happen. So a trust can be useful. Would I say that it's going to have a ton of effect on the Secure Act? It could have a negative effect if it's not done properly. So be very careful whenever you're listing your trust as a beneficiary of a retirement account. Is there any way, we just went over that one. I guess I kind of combined the other one. The second question was, is there any way to simplify the distributions of retirement accounts? Would a trust be advisable? So again, it really comes back to when we're using a trust as a beneficiary for retirement assets, we're doing it mainly for asset protection purposes. There's other reasons we could do it as well, but I kind of combined two questions in one. So if that was a little confusing, feel free to shoot me a follow-up email on that. Okay, scenario. Someone writes in their will that they want their retirement money to go to their nieces and nephews, but their IRA lists a single beneficiary who was an adversary of the person that died at the time of their death. Is there any way for the family to recover the IRA funds? Well, there's no way I can actually answer that question directly because so many more details we would have to know. But let's look at it at least from a big picture. So generally speaking, whenever we have an IRA, whoever's listed as a beneficiary under that IRA, that money is going there. It doesn't matter what your will's going to say. So if it was a pretty straightforward scenario, then whatever that beneficiary designation says on the IRA, that's where it's going. It's not going to go in this example to the nieces and nephews. Now, having said that, if the person, whenever they filled out their IRA designation, didn't have capacity or they were under some sort of undue influence, well, then there's an argument there that was invalid, that there was basically fraud committed whenever that was written. So where that beneficiary was listed. So that could be one reason. The other way could be, well, maybe if our beneficiary, instead of being the nieces and nephews, it was a spouse. Well, spouses have certain rights to an amount of money, so that could potentially play in here as well. And we can't necessarily disinherit a spouse. So we definitely need more information to really be able to answer that question. But generally speaking, the beneficiary designation is going to control not what's put in probated assets after somebody dies, the distribution of those assets. So will is used in probate, beneficiary designation, that's more of a contract with the trust company or the company that holds those retirement accounts. Next question, what is the best way for a caregiver to access a parent's money without being on their checking account? And kind of the follow-up there is to avoid any potential creditors of the caregiver from taking money out of the parent's account. So I talk about this all the time whenever I do seminars. We have another seminar coming up next week. That's basically a Zoom call that I do with 20 to 50 people. So if you want information on that, just feel free to email me afterwards. It's billhenry, one word, @robinsonhenry.com. So back to the question. What's the best way to do it? So the first thing is, why do we not want to do it? Well, we don't generally want to put ourselves on the accounts of our parents, or should say another way, if it's your account, you don't want to put somebody else on there other than a spouse, say, because if that person has a debt, then the creditor, whoever that person that they owe the money to, can come back and they could potentially garnish that account and take our money. So let me give you an example. If I have a checking account with $10,000 on it, I put my son on that account. My son goes out and he ends up in a car accident, gets sued, and they're looking for more money, and they garnish his bank accounts. Well, that could include my $10,000. So not a good result there. Likewise, by putting my son on my account, I've got a son and a daughter. Well, now upon my death, where's that $10,000 going to go? It's probably just going to go to my son. But maybe I wanted my estate to go 50-50 to my son and my daughter. So I might have just messed up my estate plan by doing that as well. So what's a better approach to doing that? Well, we want to, instead of doing it where we put somebody on the title, instead what we would be better to do would to actually execute a power of attorney. So a general durable power of attorney, a financial power of attorney that just says, hey, my example, son, you can write checks out of this account. That's the better way to do it. That's what generally I would recommend. You could also put the bank account into a trust, a little more complicated, and then make the son the trustee in that example. So lots of different ways to do it. But to avoid creditors, we don't want to put the person on the account. Great question there. All right. Do you need to state your intentions to disinherit an estranged child in Colorado in a Colorado will to avoid them from being part of the estate? Maybe is the answer there. So let's play out a few scenarios. So the first thing to know is that under probate intestacy law, so if I didn't have a will, then my child would be one of the people that would inherit. Now, there's a lot of rules, and it depends on, am I married at the time of my death, and a bunch of other things. But let's just say I'm not married at the time of my death. So spouse either predeceased, divorced, or I never was married. And I die, and I've got 2 children, including this one child we don't want to inherit. Well, if I don't have a will, then guess what? That kid is going to get 50% if I've got 2 kids in that example. So what if I have a will, though? Do I need to specifically say that I don't want them to inherit? The short answer is no, because a child has no legal right, unlike a spouse, to any portion of your estate. So instead, in my will, I could say, upon my death, if I'm not married again, upon my death, 100% is going to go to, I don't know, some charity, give it to St. Jude's. Well, just because my son's not listed doesn't mean all of a sudden he can come back, or just because I didn't specifically say I was disinheriting my son doesn't mean that he can come back and get a portion of that. But what if St. Jude's isn't around? Or alternatively, let's say I list my brother, but my brother predeceases me. Well, what then? Well, if nobody else is listed, it's going to default back to state law. Well, I have a child, so therefore my child would end up getting something. So the best way to do this is you would absolutely list your child that you wanted to disinherit, saying, this is my child, but I also am specifically disinheriting them, and they are deemed to have predeceased me. And that's how we would avoid all these different scenarios from happening. So we'd be very specific. So best practice, we definitely want to list them and disinherit them. Do we have to? I mean, technically, no, but if you come to an attorney, of course, they're always going to do it. Okay, we're kind of slowly wrapping up here. Do I also need a will? The answer to that is yes. Technically, you don't need to actually have a will. You don't have to have a will, but what if you forgot to put something into your trust, which happens more often than not? So I have let's say I create a revocable trust and I put my house in it. But then, I don't know, a year later, I buy another house in Florida, but I don't put it into the trust. Well, then what happens? If I have a will, in my will, I can say, if I didn't get it into my trust, pour it over into my trust. So that's where I would need a will. But if I don't have that will, well, where's it going to go? We're going to default back to intestacy law. We're going to default back to state law as to where that second house is going to go. So best practice, definitely you would want a will if you have a trust. Let's see here. Final question. Does a joint tenant face any tax implications when the property is transferred to them upon the other owner's death? A little bit complicated there because there's lots of different types of tax. So I'm going to just focus on estate tax since I happen to be an estate planning attorney. The short answer is no. The joint tenant wouldn't pay the tax, but is there going to be a tax implication to the person that died? Maybe, and that just depends on how big the overall estate is. If their estate is over the estate tax limit, so for an individual, that's about $11.5 million, then there would be a tax on the estate to them. And of course, it would depend on what the law is at the time that they die. So maybe the real short answer is no, the joint tenant's not going to pay any tax. There could potentially be tax on the estate of the person that died. All right, well, I'm Bill Henry here. A little longer. You can tell it's bad. I'm just getting back a little bit slower than usual. If you've got any questions, feel free to email me. My email is billhenry@robinsonandhenry.com. I look forward to seeing you next week. If you'd like to join me for a little bit different of a format, that is where I basically do a estate planning conference where I kind of have more of a set information I'm going to provide instead of using it as a Q&A, feel free to join me. Again, email me and we can get you over a invite to that. I will talk to you next time. If you got any questions, as always, just let me know. And as always, I always have a challenge of getting it off because my cursor isn't working. So you're stuck with me here for a few more minutes. There we go.